This week on The Record, the right to carry firearms out in the open. We talk to the judge who advised City Hall behind closed doors. Planes, trains, and automobiles. The vehicles that get us where we're going rely on solid foundations. We dig deeper under concrete, asphalt, and rebar to find what pays for it all. Our one-on-one with U.S. Transportation Secretary Pete Buttigieg. All happening right now on The Record. Welcome to The Record. I'm Mark Maxwell. If you were to pick the top 10 political stories in St. Louis this year from a hat, you'd be hard-pressed to find one of them that didn't have some nexus to violent crime. From the mayor's fight with Jefferson City to retain local control of the police department, to the failed push to raise the legal age to carry guns in the state, or the ouster of former Circuit Attorney Kim Gardner, each of these issues all revolving around the police effort to improve public safety in the streets of St. Louis. And with disturbing images of young teens carrying semi-automatic rifles in the open, flashing across our screens, in between reports of mass shootings in downtown, the city could be coming closer to taking action on its own, separate and apart from the Republican-led state legislature. Alderwoman Kara Spencer won unanimous support at City Hall for her measure to require people carrying guns in the city to also have a concealed carry permit. That would automatically mean no one under 18 could carry a gun in public, adding local enforcement to a federal ban on minors carrying guns. But Mayor Tashara Jones had raised questions about whether that plan might pass judicial scrutiny. Joining us now to provide some of that judicial scrutiny, retired Judge Robert Dierker, now on the record. And Judge, we checked the record, the state law, and it says that the General Assembly, quote, preempts the entire field of legislation touching in any way firearms, components, ammunition, and supplies. But you seem convinced that the preemption here, there's a path through it. If someone pulls a gun out or pulls the trigger, that's the catch.
Well, the statute preempting local control had a specific proviso that the Board Bill 29, the city proposed ordinance, mirrors. And it had a very specific language allowing local governments to regulate certain aspects of possession of firearms, particularly open carry. So the state statute contemplated exactly this type of regulation.
And yet that regulation, that avenue, seemed to be hiding in plain sight for some time. Any idea why?
It was. Well, I think partly because it was in a section of the revised statutes that you would not normally look at for this language. And I confess that I didn't see it when it was enacted. It was brought to my attention when an attorney, I think it's Joe Taylor, wrote an opinion and cited Chapter 27. And so when I looked at Chapter 27, I thought, oh, yeah, there it is. It's an open door for this very specific regulation.
I see. And we brought you here, invited you here in part because of the letter that you wrote to the Board of Aldermen that said the new open carry or concealed carry permit ordinance is one of these four things. Your letter said this, quote, 1, it's within the authority of the city charter. 2, it's in complete harmony with state law. 3, it conforms to the Second Amendment and the Missouri Constitution. And maybe the most important part, your opinion that it would most likely be upheld by the courts. How did you reach that fourth opinion, that the courts wouldn't overturn this?
Well, I mean, the conclusion follows from the earlier analysis. The city charter gives the city considerable authority to regulate a lot of things. And so there's clearly no problem with the city. For many years, the city had a locked container ordinance, which was never challenged. It was seen as within the city's police power, consistent with its constitutional charter authority. And then the statute on preemption of gun regulations by localities had this specific exception. The Missouri Constitution, well, I mean, I confess, you know, I ruled on a couple of cases involving Article 1, Section 23 of the Missouri Constitution as it was amended, and I held that the statute on felons in possession could not be applied lawfully to nonviolent felons. The Missouri Supreme Court reversed me, so I have direct experience with construing Article 1, Section 23, albeit wrongly, as it turned out. And then the Second Amendment cases, the New York pistol and rifle case, which I've read carefully, I think all of those, you have the necessary authority in the city, you have the statutory authority, and you have the constitutional authority, because this type of regulation, which is not an absolute ban and does not impose insuperable barriers on people being able to carry weapons, but is a licensing regulation of a type that historically has been upheld. So I think it passes muster under all, from the standpoint of all sources of authority.
That's your legal analysis. I think some
Right.
political observers were surprised somewhat to see you involved in this, let's call it a progressive city hall. You write at some length about the Second Amendment in your book, The Tyranny of Tolerance. This is a quote, 2 excerpts from your book, quote, "Along came the illiberal liberals to whom armed citizens are anathema." Another quote, "Liberals have a way of ignoring the truth about the right to keep and bear arms." Your legal analysis here almost looks like you're in league now with these liberals that you criticize.
Well, I told Alderman Spencer that the two extremes have met in the middle here, and we find ourselves agreeing with each other on this particular proposition. And obviously I could be accused of switching sides, but I don't think so, because I think historically this is the type of measure that is entirely consistent with the original understanding of the Second Amendment. And so in that regard, I don't see myself as going against originalist principles or the principles of constitutional construction that I believe in.
This passes constitutional muster from your vantage point. I want to ask you, though, in addition, about your experience from the bench, because I imagine you've seen and you've written about criminal law. In your experience from your vantage point throughout the course of your career, have you seen clear and convincing evidence that, in fact, laws do deter some types of crime?
Well, you remind me of comments I made from the bench and doing guilty pleas on people with weapons violations. So many guns around town and so few brains. But I think that I think that the criminal law does have an effect, and I think there are some people who are completely indifferent to it, and some people who quite happily, deliberately violate it. But I think most people tend to try to obey the law, and I think the criminal law clearly has this essential role of restraining and regulating. And so I think it can have that effect. Obviously, the people I saw in court were the kind of people who were not so meticulous about obeying the law. But I think that in general, the people who did violate the law, the majority of them would get probation and were not violent people, and they would reform, if you will.
I hear you. So an interesting look behind the scenes at some of the legal analysis undergirding this new board bill. Judge Dierker, thank you for your time.
Happy to be here.